A very good morning and a warm welcome to one and all present here. We have today the 12th NEETI Talks organized by the NEETI Forum of JSS Law College Autonomous. And we have with us a very distinguished personality and one of India's foremost jurists and the 46th Chief Justice of India, Honorable Mr. Justice Ranjan Gogoi, sir. Without further delay, I now request our Chief Executive, Professor K.S. Suresh, to welcome the gathering and also to introduce the guest. Over to you, sir.
Very good morning. Honorable Justice Shri Ranjan Gogoi, Principal, faculties, dear students, invitees, and the press. We are singularly fortunate to have with us this morning the most distinguished former Chief Justice of India and Rajya Sabha member, Honorable Justice Shri Ranjan Gogoi. It is indeed an honor to welcome him to this program. Honorable Justice needs no introduction. However, I try capturing his personality in few following words. Justice Ranjan Gogoi, the 46th Chief Justice of India, is renowned for his tenure on the Supreme Court of India. Serving from October 2018 to November 2019, his career was marked by a reputation for bold, pivotal, and landmark decisions. Some key attributes and contributions associated with Honorable Justice Gogoi are his judicial legacy. Justice Gogoi presided over several landmark cases, including the historic Ayodhya land dispute case, which resolved a decades-old conflict. His tenure also saw judgments on issues such as Rafale, fighter jet deal, and Assam NRC. Firm and resolute, known for his strong judicial temperament, Justice Gogoi was regarded as a no-nonsense judge who maintained a strict approach in the courtroom. His leadership brought significant attention to cases impacting national and constitutional significance. Focus on accountability. Justice Gogoi was part of a notable 2018 press conference alongside three other senior Supreme Court judges, which pointed out concerns about judicial functioning and transparency. This move was, though unprecedented, but underscored his commitment to judicial integrity. Constitutional priorities. During his time as CJI, Justice Gogoi prioritized cases that upheld constitutional values and aimed to resolve complex societal and legal issues with an impartial hand. Post-retirement role. After his retirement, Justice Gogoi was nominated to Rajya Sabha, Upper House, in 2020, where he emphasized his intent to contribute to legislative processes. Recognition. His tenure was highly impactful, drawing both praise for his delivering timely and decisive judgments. Justice Gogoi's career continues to be discussed for its significant impact on India's legal landscape, reflecting a judge committed to upholding the law with a strong and assertive hand, navigating both commendation and critique. Justice Ranjan Gogoi studied at Cotton University and later completed his higher studies at the Faculty of Law, University of Delhi. He enrolled at the bar in 1978 and practiced at Guwahati High Court under Advocate J.P. Bhattacharya. His lordship began his practice independently in 1991 and became a senior counsel in 1999 at the court. In 2001, he was appointed as permanent judge of Guwahati High Court. In 2010, he was transferred to Punjab and Haryana High Court and became Chief Justice in 2011. His lordship served as 46th Chief Justice of India from 2018 to 2019, having previously served as judge of the Supreme Court of India from 2012 to 2018. He is also the first Chief Justice from Northeast India. Justice Ranjan Gogoi is currently member of Rajya Sabha, having been nominated by President in 2020. He is also a member of the Committee on External Affairs in the Rajya Sabha. He is the third Supreme Court judge to become Rajya Sabha member after Justice Ranganath Mishra and Justice Bahrul Islam. He also has written an autobiography titled Justice for the Judge, an autobiography, and that book is available in the library, and many of us actually have read that book. It's a very interesting one. In 2019, he was listed as the third most powerful person in India by the Indian Express. Some of his lordship's landmark judgments, I'll be very brief in this regard. CBI versus Union of India, where three-judge bench led by CJI Gogoi held that the divestment of the director without the selection panel authorization was illegal and reinstated Alok Verma, who was divested of his post at midnight through a union government order. B. Singh versus Delhi Jal Board, where CJ Gogoi-led bench held that a member of SC/ST community from one state cannot claim the benefit of reservation in government jobs or admission in another state if their caste is not notified there. It's a very significant judgment. Indira Jaising versus Union of India, where judge bench comprising his lordship established the permanent committee for designation of senior advocates to ensure transparency in both Supreme Court and High Courts. Resurgence India versus Election Commission of India. In this case, the bench comprising his lordship set stricter requirements while assessing men to ensure that electoral candidates honestly disclose their assets, their education, any criminal antecedents as antecedents. Before this judgment, candidates could leave the sections of their disclosure affidavits blank. And CPIO, Supreme Court of India, and Subhash versus Subhash Chandra Agrawal, a very significant judgment as far as the Right to Information Act is concerned, where the Constitution bench of the Supreme Court of India ruled that office of the Chief Justice of India would also come under the ambit of Right to Information Act 2005, as CJ is a public authority under RTI Act. And lastly, and very important one being Mr. Siddiq versus Mahant Suresh Das Ayodhya, that is usually called as Ayodhya case. It awarded the title to the deity Sri Ram Virajman and directed the state to grant the Sunni Waqf Board 5 acres of prominent location in Ayodhya for the construction of the mosque. It is indeed our privilege and honor to have with us this morning Honorable Justice Sri Ranjan Gogoi ji for the discussion on the role of courts in India in the last 75 years and the challenges ahead. I extend him a very, very warm welcome on behalf of everyone who is present. I also extend warm welcome to my principal, Dr. Vanishri. And I also extend warm welcome to the faculty, students, invitees, and the press. Thank you very much.
Thank you, sir. I also welcome you too to this event. Well, now we have the second session to this program, where His Honorable Lordship will introduce the topic, followed by the interaction on the same topic through the moderators. I now request Ms. Nikita Susin and Ms. Shashwati to kindly come to the stage.
Very good morning to all of you. Professor Suresh, Dr. Vanishri, the principal, members of the faculty, and a very dear teacher, Pranav. Now, it is because of his insistence, or rather I should say because of his persistence for the last 2 years, that I'm here today. Professor Suresh Dr. Vanisri and the members of the faculty, thank you very much for inviting me. It's such a pleasure. And my dear students, what really was the turning point for me to come to Mysore? I am semi-retired. I spoke to a colleague, a former colleague of mine, Justice Ramasubramaniam, and I asked him about JSS Law College. You know what he said? He calls me Chief. Chief, go there. Two of my law clerks have graduated from JSS Law College. I don't think the college needs a better introduction. Justice Ramasubramaniam is a very scholarly judge. My dear students, let me start by complimenting you on the choice of law as a field of study. Law is omnipresent and career-wise, it has infinite capacity. You could be a lawyer, you could be a teacher, you could be a judge, you could be a corporate executive, would be working in a law firm as a litigation lawyer. There are so many opportunities. Of course, if I may say so, I would recommend that all of you come and join the courts. Speak your mind out. Try and convince two very senior people or one very senior people, the judge, and try to win him over to your line of thinking with all persuasion. That is why I thought I'll speak to you for about 20-25 minutes on the topic, and then we'll have an interactive session. The interactive session, the idea is that participation, which you will have to do, speak out in the course of your life. There is another very special reason why law as a subject is very important. Now, the judiciary today stands as the last bastion of hope for the common man. Lacking the might or resources, the common man turns towards the judiciary, looking to courts as avenues for justice. With the judiciary's support, an ordinary individual armed with the gavel and the constitution becomes as influential and empowered as these symbols themselves are. Judiciary is the beacon of hope that lights the way. You should feel proud that you are aspiring to be a part of this great institution. A court of law signifies a pillar of hope that exists in the heart of society. The hope is for justice. Every person who approaches the doors of our courts comes with the hope that justice will be done. Our courts, therefore, narrate countless top stories of hope. The moment hope fails in the hearts of the common man, questioning whether this institution will stand by them, that is the moment we risk losing the essence of our existence. A robust democracy, which is the constitutional goal, can only be sustained by the pillars of a strong judiciary. The judiciary has its anchors in independence and impartiality. India, embracing this concept, has positioned its judiciary to serve as an essential balance against the legislative and executive government, ensuring that no single entity wields unchecked power. I would say that today, the judiciary's primary duty is the solemn and critical interpretation of the Constitution, a document which, much like the nation it governs, is subject to the winds of change. As society evolves, new challenges and complex questions arise, necessitating that the Constitution adapts to contemporary realities while remaining true to its foundational principles. It is within this dynamic environment that the unique symbiosis between the Constitution and the judiciary manifests. The judiciary does not exist in status. It matures in conjunction with the Constitution, simultaneously guiding its progression. With each interpretive act, the judiciary breathes life into the text, allowing it to function as a living document that is relevant to the people it serves. In doing so, the judiciary aids in sculpting the nation's legal landscape, ensuring that it remains just and equitable for all citizens. Today, we find ourselves in an era where our societal fabric is intricately woven with the threads of law, economics, environment, and technology. The decision made by India's higher judiciary today has reached far beyond the courtroom. They ripple to the very pulse of our nation's stability. By interpreting and reinterpreting the Constitution with wisdom and foresight, the judiciary reaffirms the rule of law and reinforces the fabric of democracy. It ensures that the Constitution remains an enduring testament to the principles of justice, liberty, and equality, even as it evolves to address the trials of an ever-changing society. In this way, the judiciary is not merely an arbiter of laws, but an integral protagonist in the nation's narrative, guiding its journey through the annals of time towards a most just and democratic future. And what could be a better testament to the evolution than the role of the judiciary in the last 75 years? In the years following our independence, India embraced socialist ideals. The aim was to create an egalitarian society through state-led economic policies. This was reflected in our laws and the judgments of our courts, which often prioritized the collective good, state control over resources, and the redistribution of wealth. It is within this context that the judiciary operated, balancing the aspirations of a newly sovereign nation with the rights and liberties of its citizens. However, the winds of change began to sweep across our nation in the early 1990s. India stepped into a new era of liberalization, privatization, and globalization. These economic reforms transformed the landscape of our nation, sparking rapid growth, increased investment, and integration with the world economy. It fell upon the judiciary to navigate these troubled waters, ensuring stability, fairness, and adherence to the rule of law. The Supreme Court of India and the various high courts had to assume a proactive role in interpreting the Constitution in a manner that fostered economic liberalization while upholding fundamental rights. Judgments of the court had to adjust the scales of justice, ensuring that while the market was allowed more freedom, the vulnerable did not suffer as a consequence. Its duty was to strike a balance ambitious enough to allow economic innovation to flourish, but prudent enough to mitigate its excesses. The shift from a controlled economy to a free market required the judiciary to redefine the scope of states' intervention in business. The judiciary became the interpreter of a dynamic economic language, sometimes criticized for its significant involvement, yet undeniably crucial in upholding the principles of equity and fairness. In seeking a prosperous future, India, you will agree, must not merely focus on the visible indices of economic growth, but must also ensure that such growth translates into tangible benefits for all its people. Bridging the divide between progress and social welfare, the judiciary enshrines its role as a protector both of economic dynamism and public's moral and material interests. This dual responsibility is the hallmark of a judiciary committed not only to the rule of law, but also to the ethos of a just society. Agrarian reforms, abolition of jamindari and the privy purse, initially negating, but subsequently upholding the nationalization of banks, and still subsequently permitting liberalization and privatization are all instances of judicial balancing of a new economic era with the changed social equations. This is only a small part of the progressive judicial functioning, upholding of fundamental rights and holding the state responsible for infringement of fundamental rights, championing the freedom of the mind and the body, has hardly left any area of human life beyond the judicial compass. At this stage, my dear students, let me very briefly tell you about what I consider to be some landmark judgments. To my mind, correct me if I'm wrong, post-independence, there has been two significant judgments of the Supreme Court. Keshavananda Bharti is not one of them. I repeat, whether Keshavananda Bharti is an authority or the basic structure, I have my doubts. Read that small book by Andhra Arjuna, who was a junior to CY in that case. Read that book. To my mind, the two significant judgments is Maneka Gandhi and Kohil. Why Maneka Gandhi? My reason for putting up on top is you can deprive a person of his fundamental rights by framing a law. That was the thinking. The law is supreme. Maneka Gandhi said, no, the law is supreme, but that law can be tested on the yardstick of fairness. This is Maneka Gandhi. Kohel, my mind, is very significant because laws put in the 9th schedule, which is beyond judicial scrutiny, also have to conform to fundamental rights. These are, to my mind, very significant judgments. But of late, I must tell you, there are about 8-9 judgments which are significant. The electoral bonds case. I'm not opining whether it is right or wrong, whether judgment is good, bad. What I'm saying is it's significant. The electoral bonds case deals with political funding. That's why it is important. A very recent judgment of the 9 judges that not all private properties can be deemed to be the material resource of the community, again, is very significant because it is a change of direction from an earlier bench, the views of an earlier bench. Article 21, privacy, the right to privacy. Very significant because in these days of, this was a judgment in the context of the IT Act. And in these days of digital surveillance, the right to privacy being a part of Article 21 is something very significant. In the Delhi government tussle between the Lieutenant Governor and the Chief Minister, the judgment, the significant part of the judgment was that the bureaucracy is responsible to the legislature. I wish the Supreme Court had expounded it more, but it stopped short. But that is the moral of the story. I think it's very significant because I can see a lot of things happening on that front. The responsibility of the bureaucracy, not to the political executive, but to the legislature. Young people, the right to marry a person of your choice. Not going to the same sex, but a person of your choice, a part of your right under Article 21. Section 377, striking down gender equality, the right of choice. Sabrimala, but I will not comment because as a party to that decision, that case is pending. So Sabrimala is out of bounds for me. Decriminalizing adultery. Article 370, Kashmir. These are some very significant constitutional marches. Whether you agree with the march, whether it should be right, whether it should be left, whether it's good, bad, that's another thing. That's your privilege. But the point that I'm trying to make before you, and you'll be using this language in courts, always you did. The point that I'm trying to make before you is this. These are forward marches so far as the Constitution is concerned. Whether these are good or bad, only time will tell. Now, let me speak of something which is very dear to my principal's heart, I understand. The role of the court in maintaining ecological equilibrium and navigating the economy. I believe your principal has a fascination for environmental. And why not? That is what is coming. The Indian judiciary has played an enormous role in harmonizing the dual objectives of fostering economic growth and preserving the environment. Delicate balance, it has adeptly maintained through numerous judgments. The verdicts of the Supreme Court reflect a nuanced understanding that sustainable development is the cornerstone of a progressive society. By integrating environmental considerations into economic planning, the judiciary has sent a resolute message. The environment cannot be compromised for short-term gains. The courts have time and again set legal precedents that emphasize the necessity of intergenerational equity, ensuring that natural resources are used judiciously to meet the current needs while safeguarding them for the future generations. Through these decisions, the judiciary has not only protected the environment from potentially destructive industrial and governmental actions, but has also reminded these bodies of their intrinsic obligation towards environmental stewardship. The judiciary's environmental jurisprudence also recognizes that a healthy environment is a part of the constitutional right to clean environment, a very important facet of the right to life. It's not possible, and of course it's not necessary also in view of the interactive session that we're having, for me to be comprehensive enough on the judiciary's role in molding the life of the nation and the citizens. I would say that there is hardly a single aspect of life that is not subject to court proceedings, so much so that the innovative march, the jurisdiction of the courts into new areas every day has given rise to serious debates on the true role of the Indian judiciary under the country's constitution. Now, this is something for the younger generation specific. What are the pitfalls that you must rescue the judicial system from, which our generation could not do fully? Now, around the world, nations are recognizing the urgency within which their judicial systems must develop. A functional judiciary endowed with sufficient resources and personnel is not a luxury, but imperative for the sustained development of any nation. The repercussions of a stalled judiciary are not only confined to the economic sphere. The social implications are equally profound. In the absence of timely justice, the public's trust in the institution wanes, and the rule of law is undermined, affecting the nation's overall well-being. The economic surveys of the Government of India indicate that the backlog that plagues our judiciary acts as a significant impediment to India's GDP growth and investment climate. A vital aspect of the judiciary's efficacy would be its capacity to efficiently manage caseloads. This is an area of serious concern. Much has been talked, much has been debated, little has come out of it. I hope in the interactive session we can interact on this area. What is the way forward? I don't think we are without a solution, but I will save it for the interactive session. There is another area which I would like to focus on 2-3 minutes, and then I'll close this. This is the jurisdiction of the public interest litigation. PIL is a double-edged sword. It has potential pitfalls. On one side, PIL has been instrumental in effecting landmark changes in various sectors, including governmental protection, human rights, and government accountability. On the other side, the broad latitude provided by PIL has sometimes led to what can be seen as judicial overreach, with courts encroaching upon the domain traditionally reserved for the legislative and executive branches of the government. Additionally, the rise in frivolous, motivated, vexatious PILs has sometimes burdened the already overextended judiciary. These are some of the perceptions, or rather, these are the perceptions of some of the people. Whenever I go to Parliament, and I do go to Parliament, a huge number of these questions come. Sir, is the judiciary not overreaching? Difficult question to answer, but it indicates what is in the mind of people behind the glass house of the judiciary. When you are in the judiciary, you are very protected by the law of content. When you step out, you face the reality. And I have the good fortune of facing the reality, and the equally good fortune of sharing the reality with you. I think this should be enough of an introduction. I look forward to the interactive session, which we can go until about 1 o'clock, 45 minutes. That should be efficient. Thank you.
Thank you so much, Your Honorable Lordship, for giving us a wide interpretation on many important facets of law. Moving further, we will now have the interaction session moderated by Ms. Nikita Susan and Ms. Shashwati.
Very good morning to you, sir.
It is no longer morning, it's afternoon.
Very good afternoon to you, sir, and I wish all of you a good afternoon too. I'm Shashwati from 4th year BA LLB, and with me I have Nikita Susan from 5th year BA LLB. Firstly, thank you so much, sir, for such an insightful talk. Now, we'd love to delve deeper into the subject matter. With your permission, may we start the interactive session. Thank you, sir.
Sir, if you may permit, I would like to ask you the first question. So, do you believe that the judiciary is truly independent, or is it largely perceived as such only on paper?
I'll answer your question with a question. How independent are you? The judiciary is as independent as you are. You are independent?
As of now, not yet, sir. As of now, I'm not independent. I'm not independent.
You are not independent. Well, dependence on parents is not being losing your independence. They are guiding you.
Indeed.
But coming to your question, yeah. My personal view is the judiciary is largely independent. Largely independent. And I would like to keep it here only. Unlimited independence also brings in lack of responsibility. By independence, you don't mean interference. By independence, it means controlling factors, yardsticks, benchmarks, keeps the judge aware of how much and no more. Yes.
Indeed, sir. Thank you, sir. So my first question to you. You mentioned that the judiciary's primary duty is the critical interpretation of the Constitution. The appointment of judges being such a vital part of the functioning of the courts. Now, the collegium system does not directly draw its roots from any particular constitutional provision or a statutory provision. The collegium, the word is not mentioned anywhere. Now, on this background, were there any missed opportunities when we struck down the NJSC framework?
The striking down of the NJSCA is a judicial act. I wouldn't like to comment. It's not fair on my part to comment on whether it's right or wrong. But we had good judges appointed when before the collegium came into being, and we had good judges appointed after the collegium came. The same holds good for bad judges. The government appointed bad judges, collegium also appointed bad judges. The tragedy or the unfortunate part of our, ecosystem is we criticize without offering a solution, without offering a solution. This is in court, this is in public forums, this is in parliament, everywhere. We talk negatively. Has anybody come out with a system or has anybody come out with a thinking that here is a system which is better than the collegium system? Have you come across?
Not yet.
No. If tomorrow if somebody comes and says, look, I have evolved a system which I think is better than collegium, I'll certainly welcome it. But collegium is bad, judges are appointing judges which are trenching upon the executive power. Look, at the end of the day, what do you want? You want good people to be judges, right? Whether the good judges are being appointed by the government or by the judges themselves, how does it matter? You want good judges. The question is, are you getting them? You're not saying that the judges appointed by the collegium are bad. Are you saying that? No. You're saying the system of appointment of judges by judges is bad. What is bad about it? At the end of the day, it is the product that matters. And if you don't have a grievance with regard to the product, why have a grievance with regard to the system?
So, regarding the system, the collegium system is largely opaque. There have been talks going on about its transparency. Would you like to comment on?
What do you want to do? To issue a public advertisement for appointment of Supreme Court judges? Right? Or you want a newspaper advertisement? Applications are invited for 6 posts of Supreme Court judges. Pay scale, this, that. They will be subject to disciplinary control of XYZ, Chief Justice of India. You were talking about independence. That's one facet. The judges of the higher judiciary don't have ACRs to be. So that's it.
Right. Thank you.
So the next question is, are media trials, including social media and public opinion, influencing the judicial mind?
Social media and
Public opinion, influencing the judicial mind.
if you become a judge tomorrow, will it influence you?
So on paper, it must not
No,
influence.
no. Let's forget the papers. I'm asking you, if you become a judge tomorrow, will what is written in the papers influence you?
Indeed, no, sir. I would try to keep an open mind.
Then you will be a good judge. Do you want to become a judge?
Not really, sir.
Not really. Why?
So because there are a lot of constraints that come with the profession, sir. That is one of the questions I would love to ask you also. It is that as we as law students feel that there are a lot of restrictions that come with judgeship. So what suggestion would you give us as law students regarding the same?
Do you want me to answer the last question or the
So both one of you.
constraints? No, to become a judge, it's a very conscious decision. Don't become a judge if you don't want to. Judge for yourself whether you're fit to be a judge, because the life of a judge is a life of huge sacrifice. But if you are a little introverted, you like your own company more than other companies. If you like to be on your own, become a judge. It gives you an excuse not to go to places. You can say, I'm a judge, I can't go to this marriage. I'm a judge, I can't go to this social gathering. You say it because you're a judge, but you say it because you really don't like going to for this social gatherings. That's a good reason why you should become a judge. Okay. And what was your original question?
So regarding media trials.
Media trials. No. See, don't blame the social media. More potent is the mainstream media. Mainstream media is no less than the social media. Social media is anybody's and everybody's opinion. Mainstream media is supposed to be responsible opinion. How responsible it is, don't ask me.
So you're saying that it does not affect the judicial mind and.
No, I would not say it does not, I would say it should not. And judges must have very strong minds. Another unsolicited advice to you, if you don't have a strong mind, don't become a judge. You have to take a lot of nonsense. Right? So if you are weak-minded and you care for people's opinion, what people are thinking, if you're trying to build up an opinion, don't become a judge. Become a politician. The country needs good judges, good doctors, good engineers, good politicians. And there are some plenty of good politicians that have come across, very well read, very hardworking. I thought judges are the only ones who work hard. I find that many members of parliament work. They also burn the midnight oil to work very hard.
Thank you. Thanks for the answer. So my next question is regarding the ADR mechanism. Now, has
What is it regarding?
the ADR mechanism, the alternate dispute resolution mechanism?
Area.
Yes.
Yeah.
So is ADR beyond the reach of common man now, or has it been serving only the corporate world because of its expensive nature?
Has the area mechanism really worked in our country? I don't think it does. What is area? What are the different forms of area? Tell me.
There's mediation, there's arbitration, conciliation, there's also.
Mediation is only for matrimonial disputes. That is the feeling. Is it not?
That's the template.
To unite their estranged husband and wife. That is mediation. Arbitration.
There's domestic arbitration, international commercial arbitration. But
I hope I don't get quoted, but I can't resist the temptation. The less said about arbitration, the better. I don't do arbitration.
Sir, but the role of the court, it introduced arbitration, the ADR system for this resolution of disputes in a cheaper and a quicker way.
See, there are many people whose thinking is that we made a mistake in going for arbitration. Now, what do we do? They ask themselves. They ask me also in various forums. What do we do? Go to court? No go. Go to arbitration? No go. What do we do? Recently, some young people came to me. Said, sir, we want you to be our brand ambassador. I said, what for? That small time arbitration. Car loans, motorcycle loans, 5 lakhs, 7 lakhs, 10 lakhs. You know how many of these cases are pending? More than 5 crores. Do you know what is the impact on the nation's economy? Money that is lent and is not coming back by financial institutions. It's public money. So it is 5 lakhs into 5 crores. It's 25. How much is it? 5 lakhs into 5 crores. 5 crore cases. That's stuck. We go to arbitration. We earlier in our contract we had this clause. We will appoint the arbitrator. But with the Supreme Court judgment that the sole arbitrator cannot be appointed by one party, be appointed by both the parties. They can't appoint the arbitrator. The person who has taken the loan doesn't want to go to arbitration. To go to the court for a small amount of money for appointment of the arbitrator, the arbitration process is more costly than the total amount involved. That is the financial institutions. Give me a solution. You are the future of this country. What is the solution? Has anybody thought about it? Has the legal system debated on it? Has Parliament debated on it?
So, as a parliamentarian, what would be your take on it? As a parliamentarian, what would be your take on it? Will the Parliament try to bring in any amendments to the system?
You have to, I think what you have to do is encourage people to take arbitration as an alternative and only on failure of constitution. And you have to build up a culture of thinking, and maybe it will not be incorrect to presume that the majority of the people don't want to keep loans pending. They would like to settle it. It's because of some problems in paying the installments as per the time fixed, which is leading to the defaults. So if you can be liberal in extending the time, if you can be liberal in accommodating their difficulties, if they are unable to pay 5 lakhs, 3 lakhs that they borrowed, but they are able to pay 2 lakhs, take it, close it. You're getting 2 lakhs, at least, close it. That's the approach you have to adopt. And then maybe in your future agreements with the loaning, you have to incorporate more meaningful clauses in the agreement. That's the future. Yeah.
Thank you.
And mind you, on this, there's some amount of research and work going on. More than research, some amount of work is going on, and I'm optimistic.
So the next question is, do you believe AI could really support the legal system, or on the flip side, do you foresee any negative impacts?
First of all, let me tell you that so far as this technology is concerned, I am largely ignorant. And I would not like to know at this age, because it's a highly specialized field. And even if I engage myself, my area of contribution will be very small. There are people who are working, but my interaction with people who are working on this AI field leads me to believe that there is a lot of potential for the artificial intelligence sector to help the judicial system in streamlining the processes. Artificial intelligence obviously cannot be the decision maker, but perhaps it can be also in some stereotype cases like the motor accident cases. Now, motor accident is a formula case. Age, income, dependence, parental dependence, or family dependence. The age is this, the income is this, the family dependence is this, then the compensation should be this. This is how it largely works. These areas, I think, is phenomenal scope for artificial intelligence to even be a decision maker. It can churn up the compensation amount very quickly, to which the human mind has to give its approval. But the human mind doesn't have to travel that long distance to arrive at a figure. Apart from motor accident cases, and motor accident cases, mind you, are huge in number and affect a lot of families. People are waiting for that compensation package to come to resettle in life. I think artificial intelligence, apart from motor accident cases, can be very useful to the system to write stereotype orders, the adjournment orders, process not served, or an application comes to adjournment. Instead of the magistrate or the minister or even the civil judges writing with their own hands or dictating to the stenographer, this is an area which stereotype orders can be handed over, to be taken over by artificial intelligence. This takes a lot of time of the judges, so that time could be saved for more meaningful work. Yes, artificial intelligence, I think, needs to be seriously imported into our system to the extent possible.
Thank you. So my next question. A lot of my peers wanted to hear the answer from you to this question. Recently, the statue of Lady Justice in India underwent significant change. The traditional blindfold was removed. The sword in her hand was replaced by the Constitution of India. What does this signify, and how does it change the role of the courts in the future, in the coming days?
You want my honest opinion?
Definitely.
I think it is irrelevant. Whether the Lady Justice has a blindfold or doesn't have a blindfold, this is an area of very adventurous journalism, nothing else. And the emotional feelings, the so-called emotional feelings of some very progressive thinkers. See, this kind of time and debate should go into more meaningful things. Right? Whether you have the blindfold or you don't have the blindfold, if you fail in delivering the goods, what difference it makes? Tell me that. So what? Justice was supposed to be blind, so you have the blind. We have removed the blindfold, therefore there is transparency. I don't think I should be believing in God.
Thank you, sir.
So what, in your opinion, is the cause of massive backlog of cases in India? Is it the procedural loopholes, the tenure of judges, mental exhaustion, or the judicial pressure, that is the ticking clock?
Yeah, much better question than the previous one. Thank you. These are questions that are important. Yes. What is the tendency? You know,
No, sir, I wasn't able to get an accurate number of the pending cases.
what is the number? What is the number? It's available in the national data grid. What is that number?
So more than 5 crores.
When I demitted office in 2019, it was 3 crores. With COVID, it became 4 crores. With debates on unnecessary things, it became 5 crores. And if you go on debating on unnecessary things, and if the judges keep on defending themselves, it will be 6 crores. Right? I indicated when I was outlining in my speech that what is the way forward? We talk about it in the interaction, so I'm happy you asked this question. This is the question. This is the most vital issue concerning the Indian judiciary. It has to do with its credibility, it has to do with its very existence. Out of the 5 crore cases that are pending, I think half of them are meaningless cases or these are dead cases. Meaningless because your traffic challan cases are also regular cases that come in the national data judiciary. So if you are doing 50,000 traffic challan cases this month, another 50,000 will come because people will keep on making the same mistakes. So far as parking and overloading, etc. is concerned. So this is a perpetual line of cases that will keep on coming. So you are doing 50,000 cases and another 50,000 is coming, therefore the number is at 5 crores, the number is not coming down. And what are the dead cases? Recently, I was interacting with some judges, sitting judges of a very well-known high court in North India. So one judge was doing criminal cases, criminal appeals. So I asked him, criminal appeals you are handling are which? He said 1984. The appeals were filed in 1984, 40 years back. When was the offense committed? Maybe 74. Because in India, the trial doesn't take much time. Things take time at the appeal stage. And he confided in, sir, I think all these are dead cases because the accused are no. The accused are not immortal. They will also die. And along with them, they are dead, the cases die. This is the accused in all property, they have died. So, still, why don't you close the cases? Sorry, if I close the cases, I can only do that on a report that the accused are no more. If I close the case saying the accused has died and the accused is alive when he comes and says you have died, made me dead and close my case, what do I answer? And in another case, there are 3 accused, 2 died, 1 all probably died, that report has not come. So he is constrained to keep his cases pending. Civil cases, how many years of litigation? Many of the next generation people don't want to continue the litigation. There was this young lawyer who came and met me and said, sir, my mother was involved in a litigation and she has passed away. I don't want to continue this litigation because this litigation is a very sore point. So what has to be done is Find out. Take this traffic challan cases out of the grid. Find out the dead cases. If you succeed in reducing your figure from 5 to 3, you are more comfortable numerically. Correct? That's the first step. Now, who will do it? So far as the trial courts are concerned, courts can do it only when there is direction from the High Court. Unless the High Court directs, the trial court can't do it. Why will the High Court do it? Questions will be asked. You see, the problem in this country, or the problem with human existence, is you are misunderstood for everything. And each High Court judge, each High Court Chief Justice would say, let me pass my tenure. I don't want to get into trouble. I don't want to get into controversy. Shrugging shoulders. This is the problem with the judiciary. I do not know what is the problem with the government, but I know what is the problem with the judiciary. This is the problem. People don't want to take hard decisions. Think the problem of pendency to a large extent is eminently solved. And I wish you asked me that question as a separate question about the appointment of judges in the lower judiciary, in the base cadre, civil judges, magistrates. Whenever you talk about the Indian judiciary, what do you talk about? Two things, which you have already talked about. Independence of the judiciary and collegial system. Has anybody ever debated on what is happening in the trial courts? How the trial, what are the obstacles, what are the difficulties faced by the trial judge? What is the recruitment process for trial judges? How long it is, how many vacancies are there of trial judges all over the country? Has anybody talked about it? No. Why would you? You're not interested. You're interested in gunning the system. And to gun the system, you need two topics: independence of the judiciary and collegium system, which you talked about. Yes.
Yes, sir.
So the two things you mentioned was definitely one of my questions. So I think I'll start with that now. Do you think that any reform is required in the quality of appointment of trial court judges?
Yes, now that I said, I wish you asked me a separate question. I'm glad that you've done that. You see, first of all, appointment of trial court judges, that is the prerogative of the High Courts. Because the trial courts come under the administrative superintendence of the High Courts. Now, the recruitments to the lower judiciary do not take place in time. In spite of a time schedule being laid out by the Supreme Court in Malik Majar case. On this date, you have to issue the advertisement. You have to complete the preliminary exam by this date, the main exam by this date, the interviews by date this, appointment by this date. So in the course of 1 year, the existing vacancies, anticipated vacancies, calculate everything in them. Not being found. Now, so far as the appointment process is concerned, You are testing the prospective judges in different branches of it. That's fine, that's fair. But there are certain areas where you test them further, which a person will not learn in law colleges. That is, what is this man's commitment? Is he going to treat the job of a judge as a 9-to-5 job? Or is he going to take as a whole lifetime's commitment? That is why I said, we don't have to become a judge. Don't become a judge unless you are sure of yourself. See, a person who's academically very bright and gets good marks in the competitive examination, recruitment examination, may not be a very bad judge because he does not treat it as a commitment, he treats it as a job. This is one quality that you have to the present system of funding has to cater. You have the right people at the right place, doing the right thing, things will work. You recruit mechanically, no matter how hard you try, you're not going to get the right man. Yes. And when a judge joins at the lowest level, civil judge, he's maybe about 25, 26 years old, he or she. 25, 26 years old. You may have a career of another 35 to 40 years. So he is not committed. He is not committed for the next 40 years. And if even 20% of the judges are not committed for the next 40 years, think of the havoc. You have brought into the system people who know many no good judges, being judges, they may be very good elsewhere. So I think recruitment to the lower judiciary, trial judges, require a very serious thinking. Unfortunately, the thinking, I would say, has not yet started. I would say it is not even conceived. What is the material that we are looking
Sir, adding to Nikita's question and to your answer, do you think reforms in legal education system can give us better judges if we're speaking of their commitment to the job?
The legal education system, I like to share with the members of the faculty, is in need of serious overhaul. We are largely following a system that is highly outdated. Law is a subject of perpetual learning. I learn even today new things. Therefore, out of the box thinking, you can't keep on changing your curriculum every year. But out of box thinking, innovative thinking, innovative motivation, these are very important contributions of the faculty. Now, there are not too many law graduates. How many of you would you like to be a law teacher? You said you want to become a judge. Would you like to be a law teacher? No, I said both of you. This is to both of you. Would you like to be a law teacher?
It's not a full-time law teacher.
Not all. Somehow, look, the legal education is at the root of it. Unless you have good law teachers, you can't have good students. Unless you have good students, you can't have good lawyers. Unless you have good lawyers, you can't have good judges. People like But people don't want to become law teachers. Why? And if we can answer why, are we going to do something about it? I think the best minds should be the law teachers. In the IIMs and the IITs, the teachers are the best minds in the field. I'm sure there are many bright, brilliant law teachers, but we need more of them. We need people who want to be law teachers. And I'm telling you, I had a law intern, no, not intern, a law clerk. And the young lady of 24, 25 asked her, what do you want to become? She said, I want to become a law teacher. I said, why? She said, no, teaching is my passion. I think law teaching is great. I'm going to churn out good lawyers. And today, at a very young age, she's doing very well in I think in Ajit Premji University in Bangalore. So there are people. You don't want to become a judge. You don't want to become a teacher. What do you want to become? Tell me, please.
Advocate. I want to become an advocate.
Oh, you want to become a lawyer? That's good. That's good. Yes, your next question.
So courts have frequently advocated for the Uniform Civil Code. So in your view, could UCC strengthen India's secular fabric?
Is Uniform Civil Code not one of the directive principles? The idea of putting it as one of the directive principles is that the constitutional vision was that perhaps one day, when we are all ready, we will have a uniform civil code. So there is no running away from it. The question is when? Are we ready for it today? Are we ready for it tomorrow? When will we be ready for it? These are difficult questions to ask. These are highly sensitive and politicized questions. I would not like to answer our state of readiness, but it is a constitutional vision and we all share it.
Thank you.
So my next question is regarding the UN policies. Are they affecting the Indian courts in awarding capital punishment?
What?
The UN policies, the United Nations policies.
I didn't understand your question.
So are the United Nations policies affecting the Indian courts in awarding capital punishment and
Okay.
thereby upholding the human rights of the convicts than the victims?
No, thanks. No, I don't think so. Death penalty, capital punishment is very much one of the prescribed punishments. In spite of the clamor for abolition, the new laws have retained it. The law in the area of death penalty, forgive me for saying it, is as confused as any other area of law. And bound to be. The rarest of rare cases. What is the rarest of rare cases? Look at our criminal laws. Sentencing is a major issue with the court. It's highly discretionary. If you look into at least the old Indian penal code, you will find expressions like not less than 10 years. One expression. Up to 10 years. What does it mean? Not less than 10 years. Does it mean from 1 day to 10 years? Not more than 10 years. 1 day to 10 years. This is only something that the judge is aware of. And it casts on him a huge responsibility in sentencing. Similarly, which are the cases for capital punishment, which are the cases for death penalty. Huge discretionary area. And therefore, I said it's very confused. On a given set of facts, Judge A will impose the death penalty, Judge B will not impose the death, and both may be right. So I don't think there is any influences from any external sources. The problem is you are not very sure. And by disposition, the one judge may be liberal, one judge may be very strict, one may not want to impose the capital punishment, another may want to impose, has no difficulty in imposing. So these are individual perceptions. But I don't think there are any external forces, much less human forces. The very fact that our country has retained, Parliament has approved it, speaks for itself.
Thanks. So could you elaborate on the idea impact of community service as a form of punishment?
I was a young lawyer and sitting in the High Court. So there was this student who misbehaved with his teacher, and the teacher instituted a criminal case. The student was convicted, appealed to the High Court. Judge said, you go and touch your teacher's feet. That will be the punishment. I was shocked. Whether the judge get this discretion is not one of the prescribed penalties. But today, community service is a prescribed penalty. I think parliamentary thinking seems to be coming from the idea that apart from being retributive, punishment must also be reformative. So this is an attempt, and this is an attempt to perhaps reform a section of the offenders, smaller category of offenses. Let's see how it works.
So to add to what you just said, do you think reformative approach is the solution for India? And to add to this, do you think the premature release of convicts and the delay in executing death sentences, it has an adverse effect on society?
Now, what do you mean by premature release?
So usually convicts are released on good conduct without finishing their entire sentence in the prison.
Again, we come to what is the idea behind punishment? Is it reformative? Is it retributive? Now, if there are provisions in law which permit sentences to be cut short in some situations, that's fine. So far as delay in execution, I think the Supreme Court, and I was a part of that bench, Chief Justice Satasebam, I think, was presiding judge. We took the view that delay in execution itself is a ground to alter the capital punishment to life imprisonment. The reason, the logic in short is that the man, you have kept him every minute on tenterhooks because the warrant for his hanging may come at any moment of the day. So if the man has suffered every minute for so many days, so many years, so many months, that itself is an exonerating circumstance which should impel the court to bring down the punishment of death penalty to life imprisonment. This is the
Thank you, sir. So now we would like to move on to lighten the atmosphere and ask a few general questions to know who Mr. Ranjan Gogoi is. I will hand over to Nikita.
So I wanted to ask you as to how your life has changed post-judiciary.
Post-judiciary.
Judiciary.
That's a very difficult question. Very difficult question. But I don't miss the judiciary. I don't miss the judiciary. I did whatever was possible. And I left to the next set of judges to do what they think best. After retirement, I was nominated to the upper house of parliament. That decision was a matter of public discussion. Public perceptions are on both sides. Some say it is right, some say it is wrong. I say it is right. Right? And gets established. Right. 2001. And what was the highest court in the UK? I bring in UK because we follow the Anglo-Saxon jurisprudence. What's the highest court in the UK?
The Privy Council.
Privy Council, that is the Privy Council of the House of Lords. There were 8 members of the House of Lords who constituted the law lords, and that was the PC, and that was the highest appellate court in England. These 8 people became the first judges of the UK Supreme Court. They became judges of the Supreme Court when they were law lords. They used to take part in parliamentary debates and they used to decide cases also. So they worked as legislators as well as judges. And when they became judges of the UK Supreme Court, they had the option of coming back to the House of Lords after retirement. Okay. Not too many people know it. So it's all a question of individual perception. But Parliament is a very interesting program. Not too many people have the privilege of it there. I think it is as learned a forum as the courts are. I think the members of Parliament work very hard, and I think the Parliament library is much, much bigger than the Supreme Court library. I have visited that library. It is enormous, and there is not a single book in this world which is not available in the Parliament library. As a judge of the Supreme Court, when I wanted a particular book, that book is not available. Said, go and place an order for it. Oh, sir, we have to open a file and it has to go to the Chief Justice. He has to say yes, then the book will be released. In Parliament, there is not a single book in the world which is not available, as I said. If you ask for a book and it's not there, they will buy it from the market. If not, they will order it and give it to you. That is how a library is. So, post-judiciary, it's entirely a different scenario, a very visibly positive scenario. And that is what perhaps Lord Meghna Desai said. Why Chief Justice Gogoi? Every Chief Justice after retirement should come and sit in the Parliament. It will enrich the Parliament.
Thank you, sir. How was Mr. Ranjan Gogoi as a student? Any memorable experience you would like to share, be it in your student days or throughout your career, sir?
I think the time is running short. I'll answer the question. I have written my autobiography. I'm sure you have not read it. Read it. Yes.
Read a few parts of it, sir. So that's great.
So what legacy do you hope to leave behind?
No, I will not answer that question. There's a lot of debate on legacies. I would not like to add to the debate.
Thank you.
Any other question?
No, sir, done, sir. Now we have come to the end of our interactive
There's a
session.
gentleman who wants to ask something. Please give him a microphone.
Sir, it's been a great pleasure to be with you today. I'm a doctor. I'm doing my master's in law. With respect to a medical field, I have one question regard to consumer forum in relation to doctors. They can be litigated in 3 or 4 different forums. One is in the Indian Medical Association, one is the consumer forum, one is the criminal court, again in the civil court. And it can go on simultaneously. And it will cause a lot of problems to the doctors, their meditation, the way they have to handle the cases. And I've had a few very good friends of mine who have committed suicide on a false allegation of some problems with them. And this is an ongoing debate. It's been there for a long time. What is your opinion and how the law should be moderated with respect to consumer forum and litigation of doctors in such forums? Because they are also professionals. And very recently, few days ago, the Supreme Court has said consumer forum will not be included with respect to the litigation of advocates. And since their type of professionalism is different from other professions. And what is your opinion on this? Thank you.
Doctor, I'm so glad you asked that question. It's not a question of consumer courts having jurisdiction or not having jurisdiction. One forum less or one forum more doesn't make it better for you, so long as you are exposed to the vulnerabilities of law. I think I believe in it personally, and I think the doctor and the medical community also should make people believe, or make an attempt to make people believe that no doctor would do what turns out to be a wrong with any intention. Accidents can happen anywhere, everywhere, in anybody's hand. Accidents are not negligence. Culpable negligence, which is the highest degree of negligence, is the only area where you can hold a medical professional life. Instances of culpable negligence are 1 in 10 million. Therefore, the litigation that doctors are being exposed to is out of a personal vengeance, personal vendetta. And I think our judges are responsible enough to understand that. But then being dragged to court and kept in court for years, and to be told after 5 years that there is no negligence as far as you are concerned, that is also no pleasure. Being stuck up in a litigation for years is a very horrendous experience. That is why all this talk about speedy disposal of cases. But your medical community must spread the message, which I don't think it is doing now, that we are trying to do a good job. We do a good job. Accidents do happen. These are accidents.
Now we have come to the end of our interactive session. I would like to thank you on behalf of all of us for being so patient and answering all our queries. It has been an enriching experience to hear from a learned person like you. Thank you very much, sir.
We are coming to the end of the session. And now request our beloved principal, Dr. Vanshi, to propose the vote of thanks.
A very good morning, good afternoon to all of you present here. I take immense pleasure in profusely thanking Honorable Mr. Justice Ranjan Gogoi, sir, Member of Parliament, Rajya Sabha, and former Chief Justice of India, who has taken his time out to grace this occasion and to be with us. And also, sir, for your contribution, perseverance, efforts in delivering justice during your tenure of being a judge and the former Chief Justice of India. And I would ensure on behalf of my faculty members, also myself being a teacher, and on behalf of my beloved students, that the teachers shall be the best minds, and JSS Law College would strive to do that. And on behalf of the students, to be as optimistic as Sir was in bringing out certain of the solutions, and of course, sharing his experience about facing and sharing reality, and also the scope of many other aspects that was touched upon in his interactive session. Thank you very much, sir. I now request our beloved Chief Executive, Professor K. Suresh sir, and the coordinator of this program, Shri Pranav Kumar Nair, to felicitate his lordship.
Please be seated, sir. Please be seated. Please be seated.
I will be failing on my part if I do not thank the JSS Mahavidyapita and Swamiji to have allowed us to conduct such a wonderful academic program. The district judiciary, who have been very supportive during Sir's travel and making arrangements, the protocol officers, the police department, the non-teaching and teaching staff, and of course my dear beloved students who have given a very patient hearing to whatever Sir has said. Thank you one and all, and have a nice day.
I request the audience to remain seated and please wait till the Honorable Lordship leaves the